the respected, beloved, and honorable on the stage. Thank you so much for having me. It's usually said, experience is the best teacher. She gives lessons that last in memory. Experience is also the worst teacher because she gives the test first and the lesson later. Recently, I was telling a lawyer friend of mine how our law schools fail very miserably in equipping students to be good lawyers. I guess almost all lawyers who have seen success would claim that they learned the precious little at law school, and all the skills of lawyering were acquired by trial and error after they started to wear the robes. I was trying to establish that there must be something substantially changing in the curriculum of law schools so as to enable them to equip advocates to handle cases with some more efficiency as soon as they get enrolled. But then that friend told me that the beauty of this profession is the fact that nothing in this profession can actually be taught, but only be learned. And I think he was right. I cannot claim the experience that can parallel many of the names that adorn this meeting. But since I'm given an opportunity to address you, to introduce the subject, I would probably put in my 10 cents. We all learn that what is expected of a lawyer, we learn that a very hard way. Usually by failing to deliver what we missed. Today, the Supreme Court in one of the rulings came down and saying that once the bench has indicated its mind, the counsel must refrain from continuing submissions. I respectfully disagree with it because yesterday there was at least one opportunity when I was in court number 11 where I saw how the other side of the submissions work. Our main speaker was on his legs. They had just some, but he kept on pushing a little bit further and actually got some order in his favor. So probably the court, what it meant was you should stop telling the very same thing again and again because there should be something new. That is probably what the learned benches expected us, because I think it is actually the responsibility of advocates also to understand that our courts work on a constraint of time. We must have researched a lot of things. We have kept everything ready and we are used to come to the examination table and give all the points because all the points fetch you marks. But that doesn't work so in courts. You need not actually argue the entire case. Probably if it is possible to win the case without argument, that is how you win the case. That is a lesson that you learn pretty much the hard way once you enter into the profession. And another aspect, and I think of very momentous importance at this period of time, is the fact that no one wins an argument with a judge. And even worse, no one wins a quarrel with a judge. Because we see quarrels in the court increasing day by day for some reason. A lawyer is expected to argue, not to quarrel. He should not quarrel with the judge. He should actually not quarrel with the opposite counsel also. I cannot claim that I have never overstepped that boundary. There's at least one occasion which is very vivid in my memory when in one of the tribunals, that by an probably understood, and I was very young lawyer. I quarreled vigorously. And I used the choicest words that was in my dictionary for all protest. And I went to, if I remember, I went to the extent of using the word atrocity to describe the action of the learned member. All that I succeeded was in he avoiding the case. He avoided the case through the bundle out, through me also out. But when I walked out, there were a lot of people who were patting my back. Very well done. Somebody should tell him like this, etc., etc. But there was one lawyer, I think, with permission of all the seniors also, who was outside. He's a kind of teacher and mentor to me, just like Advocate Parvati Sanjay here. He called me. He said, "Hari, come here." And this is the exact words he used. "Hari, every single person who is congratulating you today wants to see you destroyed in this profession. And I'm telling you what you did is wrong. I want you to immediately go into the chamber and ask apology of the member." And because he said that, I had no appeal. I went and I apologized, and the member also was very kind to accept that apology, very senior member. So he probably thought this fool who is a young lawyer made this mistake. Okay, let us forgive him. And at least one good thing was, of course, the case came back to him. He had already avoided it, but at least in future cases, I did not make the mistake. He did not also show that incident in our relationships. And I'm happy that my mentor told me what he did. And I think that is something which we all should keep in mind. Quarreling is not the work of a lawyer. And of course, I am not anybody to comment on how judges should behave. But at least equally, I usually say that as good as the court halls, it is the corridors that give you enough experience in a court. So from the corridor experience, I should say that the most popular judge is not normally the most liberal judge. It is the patient judge who is the most popular judge. Uh, at the end of the day, most lawyers appearing in courts know how bad the case is. They know before they start arguing that we have a bad case, but we still argue it for obvious reasons. And probably all that they ask for is a patient hearing, a cordial interaction, and maybe even a decent burial. But at the end of the day, sometimes that is what we lack to get from the court. We get tutored, we get educated, probably somebody tries to educate, and people run into wrong side of the bench for that reason. And of course, I will not hold you back because we have a speaker who has seen both sides. In fact, he is on the back on this side of the coin once again, and is doing amazingly well. And craft is something which I adore whenever he is on his legs, very both as a speaker and as a lawyer. So I am also longing to hear him. I will leave the rest of the subject to him. Experience alone can supply what can be termed as valuable in this field of knowledge as far as a lawyer is concerned. And we are grateful that we are having such a great personality. And I should not leave the stage before I thank the organizers of this event for having given me this wonderful opportunity to think over this subject and to come and present this introductory remark. I'm extremely thankful to all the organizers, especially Unikrishnan sir and Parvati ma'am. Thank you so much for having me. And I hope we are going to have a beautiful, memorable session. And this experience will stock our talent as always. Thank you. Back to you, Gauri.
Thank you, sir, for your wonderful words. It is with immense honor and respect that I now welcome a truly distinguished legal mind, Mr. Retired Justice Dama Seshadri Naidu, now practicing as a senior advocate before the Supreme Court of India. With a career that gracefully bridges the bar and the bench, Justice Naidu brings a rare and invaluable perspective to our discussion. He began his legal journey in the trial courts of Tirupati, later practicing before the High Court of Andhra Pradesh, mastering the foundations of practice before ascending to the bench in 2013. His judicial service is a testament to his versatility and depth. He has served as a judge in the High Courts of Andhra Pradesh, Kerala, and Bombay. This pan Indian experience has given him a unique insight into the diverse judicial temperaments and practices. Beyond the courtroom, Shri Dhamasheshadri Naidu is a respected academic contributor. He is the author of the Law of Stamp Duty and Registration in Andhra Pradesh and the Andhra Pradesh Education Code. He has also co-revised celebrated legal texts such as MP Jain's Indian Constitutional Law and Vepa P. Sarathy's Interpretation of Statutes. He is also a regular guest faculty at the National Judicial Academy, Bhopal, and the Maharashtra Judicial Academy. Since returning to the bar in 2021, he has been practicing before the Honorable Supreme Court of India, bringing his judicial wisdom to bear on complex legal challenges. Please join me in extending a very warm and heartfelt welcome to our speaker, Sri Dhamasheshadri Naidu, Senior Advocate, Supreme Court of India. We also invite our speakers to share their questions in the comment box. We will be selecting a few for him to answer during the question and answer session. Over to you, sir.
Thank you very much. First things first, I'm immensely thankful for the opportunity. The whole ILI Kerala chapter has given me another window into my dearest place, Kerala, so that I could say hello to all of them. And my thanks should be to Hariraj, a good friend of mine, and we often bump into each other in Supreme Court. Whatever he has said in a matter of 5 to 7 minutes, that's been the condensed version of what I could have been telling in an hour's time. Thank you for the perspective or the window you have shown. And Madam Parvati, relentless in her pursuit, though I tried to escape on a couple of occasions saying that, Madam, I'm rather, what do you call, preoccupied. She said, nothing doing. You should come online at least. That's what I've agreed. Unni Krishnanji, thank you very much. And also, Gauri Balgopal, for the very kind words. I'm indebted. Now, when it comes to my experience, I often have said, when I got transferred to Kerala, it was my first foray outside the state. Otherwise, my entire practice was confined and my elevation was the state of Andhra Pradesh. And then my wife especially was disturbed because our children were still college going then. So she went to what you call an astrologer and asked him, why are we having difficult times? And lo and behold, the astrologer told her, it is not the difficult times. Your family is going to have best of the times. And indeed, next 5 years, I've had the best of the times. And this secret of consulting an astrologer, I revealed when I was invited as a judge in Kerala to an atheist society inauguration. As irony could have it. Well, you all could appreciate with my stay there, I'm a bit of literary buff. And have you ever imagined Denmark, in the words of Shakespeare, without Hamlet? And Rome without Caesar? Venice without Shylock? And Seshadri without Kerala? Not possible. When I was transferred to Bombay, they never knew my origins. They thought that I'm straight from Kerala, a Keralite. Naidu, Reddy, they may not know much about the origins. Well, and invariably, if there is no Supreme Court judgment, they always quoted before me only Kerala judgments. Right. Then I'll tell you, the topic is really, really quite an interesting one. I chose it for two reasons. One is that given my exposure earlier on the bench, now off the bench, both as a judge and as a lawyer, I thought I could throw some light with my experience. And in fact, Mr. Hari Raj has rightly said, this is the profession where you can't be taught, we have to learn. But a person like me, a chronic patient, may tell all of you some of the problems he has faced so that you could avoid them, if at all that could be called a learning. Well, so then I've thought that a perspective on judicial thought process and advocacy expectations. Simply put, how the judges think, what the advocates expect from the judges. And it equally applies on the converse too. So let's have a window on that one. And the second one, I have told Parvati Madam why I have chosen this topic. I know how learned you are all. Kerala is a land of learning. And if I take any subject, say a statute, you will pin me down easily for all my errors. So I never choose a topic which is verifiable and referable. I take something zany, where whatever I say will pass the buck because there is no standard to measure that. This is my selfishness. Well, now, when I was in Kerala, let me tell about the judge perspective first. I received a call from the then Chief Justice of Andhra Pradesh High Court, or Hyderabad High Court, as you know, call it, the Chief Justice. He's called me and told me, a very generous and a kind person. He told me, brother, you had been here many years practicing, got elevated, and then left this place. You're a stakeholder. You know everybody. Now I am sending names from the bar. You can also recommend a few names so that once I have a list, I can zero in on a few of them after my examining their suitability. Then I've told him, Chief, thank you very much that you have called me, but I'll tell you my experience. When I was practicing, I've seen many advocates from the bar getting elevated. On every swearing in, we'll have our own commentary. Sometimes thinking, oh, what a brilliant lawyer becoming a judge. He will set the whole legal field ablaze and he will set high standards and his judgments are to be looked forward to. This is how we have felt. Sometimes, inevitably, we've thought, oh dear, he's a zero. He doesn't know anything. ABC, he's going to be a judge. He's going to be a disaster. And lo and behold, most of the times, our expectations have gone wrong. Bench has, it seems, its own mind. Those whom we thought could be really brilliant sometimes may not have measured up to, they have wilted out or down. And someone regarding whom we have never had any expectations have excelled themselves. So I've told him, Chief, I don't think it's possible to prejudge anybody. We only have to see them only after they become judges. Whoever you feel like, please go ahead and do that one. This is why I call we have expectations. And once we have them, we only get exasperations. Now, what does a lawyer expect from a judge? You know, when I became a judge, rather before my becoming a judge, I always used to have one thing in my mind. Dear judge, you don't have any right to humiliate me. Please don't do that. And the second one is, you may have read the file, you may have already made up your mind, but hear me out. Because I am the master of the facts, because my client has briefed me on the facts. Law, as we say, your lordship knows, could be right. And whatever the length of time I was on the bench, I try to adhere to that principle. Right. Then I had a nagging doubt when I was practicing. We always say this advocate has a lot of face value before him, and he's very soft towards so and so advocate. So we'd better engage him so that we may get an order. These are the things I've had. You know, I was very critical, curious. When I became a judge, I started analyzing myself whether I have any proclivity, tendency to prefer someone to another, to have my choices of people, favorites, etc. I have realized one thing. Please remember, India, you know, the international standard of number of judges for a million people, you could have seen that one. We are not even halfway. So there has been a lot of pressure. You take American Supreme Court. In an entire year, they decide about 70 to 80 cases. In an entire year, all 9 of them on bank, they sit and they decide 70 to 80 cases. And their working days could be hardly less than or fewer than 100. Then you imagine our Supreme Court. On an average, every month you'll have hundreds churned out. If you take one bench and all their judgments, reported, unreported, their output could be in hundreds. At least 50 of them or 30 of them could be reportable. The rest are there. They work under tremendous pressure. So, what they expect is it's not possible for us to read the entire thing. So implicitly, we should trust the lawyer who comes before me or the lawyers who come before the judges and narrate the facts and the law, etc. They take it at face value. One horrifying thing or most dreaded thing for a judge is the fear of getting misled. Please remember at the end of the day, the judgment bears the name of the judge. And we always, he has wrongly decided or she has wrongly decided or rightly decided. So, given the limitations, not possible for them to cross check everything. So, please remember one thing, the dearest to the judge is the one who doesn't mislead. This is one thing. If the trust factor is there, you win the half battle before that judge. And the second one is, you know, For a judge with fixed salary, what is the pride? Which way can he claim anything as his own? If you read Richard Dawkins' Genes, Selfish Gene, you will come to know what's meant by the gene factor and also the meme factor, where you give up everything to get praised or to be recognized. Right, here a judge gets recognized only through his judgments. Once he feels, once he feels that so and so advocate does work hard, does his research well, and then puts forward his points well, and that goes a long way in his shaping his judgment, then he becomes his favorite. One is that an advocate who is not misleading him, and the other one who helps him in writing good judgments. This is the next factor to become a favorite of a judge. At least in my experience, I haven't seen somebody falling for the cause, somebody falling for the region, somebody. No. You see, the strangeness of our profession is you have to perform on your feet. If somebody recommends, if you don't deliver, the next day they will not come to you. It's a battle. Always the opposite advocate will point out where you make a mistake. Always the judge is there to see that where you have been misleading or where you have not been telling about the correct position of law. See, a doctor can as well safely practice based on his memory, based on his education, which have been, say, 20, 30 years ago. An engineer could do the same thing, but a lawyer needs to update himself every day because he's in the battlefield called court. That's why this is very, very important in my view. Then another thing is there. I always used to say to the advocates when they don't answer my question, please remember it's I who have to write the judgment, not you. So please answer me so that I can write a good judgment. It may help you in the end. I'll tell you why. Suppose you start arguing. The moment you start arguing, the judge forms the judgment in his mind. It starts. Then he will have some jigsaw puzzle, some gaps to be filled in, because he has already had a mental picture of the judgment to be rendered. And then only to be in tune with that, we question, not at all issue. This is our objective. Then he feels the moment we have prepared in a particular manner, and once that's been interfered with, we have a fear that our flow will get affected and we may be thrown off the rails, we get derailed. So we resist the questioning and say, my lords, I'll get back to your lordship's question in a while. You're off. The judge puts off his mind because his mental plan as to the adjudication has taken a back seat. So don't ever let a judge wait for your answer. Once there is a question, straight away answer that and then proceed further. Now let me tell you, there's a lot of conflict, as Hariraja said, about the bar and the bench. Why this conflict? I'll tell you a couple of reasons. Earlier I've said Wad Fransworth is an author, a lawyer turned analyst. He wrote a book called Legal Analyst. And especially first 5 or 6 chapters contain very good information for a lawyer. You know, what he says is, an advocate always thinks ex post and a judge always thinks ex ante. You know what's meant by ex post thinking and ex ante thinking? I'll explain in a couple of minutes. That is, something happens and the client or the suitor is aggrieved. He wants a redress and he goes to the court, engages you as a lawyer, and you go before the court. Your only point is, look, something has happened. My client has suffered, and whatever that has happened in the past, ex post means, remember, past PP. Whatever has happened in the past, that should be remedied, that should be set right as far as possible. If some death has occurred because of an accident, you can't bring back the life, but certainly you can compensate. He being the breadwinner, having lost his life, the whole family has to be compensated. The whole motor vehicle jurisprudence, you have seen it. and somebody lost his land, it should be restored. And somebody has promised and he has reneged on his promise, breach of contract, then you will have damages, you will have restitution. All these things could be there. So this is a remedial, this is what we think of. I've come to the court with a problem, and it's the duty of the court to find me a solution. Right. What they say is that if you buy just, I buy remedium. If there is a problem, there ought to be a remedy. This is our thinking. This is called exposed thinking. Most of the times, we find this struggle in criminal jurisprudence, especially something like bails, quashes, etc. Well, we feel that my client is innocent. He doesn't have any criminal antecedents. Why is the judge taking such a strict stand? This what you call pre-trial incarceration or pre-conviction incarceration in the name of not granting the bail is really affecting our fundamental rights, blah blah. All these things we agitate before the court. Right, this is precisely exposed thinking. How does a judge think? A judge thinks ex ante. Ex ante means, all right, I sympathize, I accept, but if I give this, if I give this relief, what is its impact on the future cases? I'll give you from Farnsworth's book a couple of examples. The classic and most well-known example is that of hijack. Perhaps down the line 3 decades ago, it was not that infrequent that in one part of the world or another, a plane was hijacked. Right? And then it's something, it goes like that one. They just have a demand saying that one, look, you have arrested a member of our band organization. We're patriots, we're fighting for our freedom, you have been oppressing us, and now you should release him unconditionally. If you don't release him, we're going to blow up the flight. 450 people will die. Common sense dictates it's 1:450. When 450 are sure to die, we need better leave that one man. Again, there's a chance of your catching hold of him so that it's a win-win bargain for us. Then what happened? In that process, we have given a weapon to lawbreakers that it pays, crime pays. Then all the countries, aviation countries, have come together. They've signed a treaty where they have said no country should yield to any hijack demand. Now you have seen it has ceased because now they have realized it doesn't pay. It doesn't pay. So that's why this is where ex ante thinking applies. For us, it applies defying common sense. I'll tell you another example. In the state of Illinois, it has happened. He has cited that one. One gun wielding robber, he came over and he put the gun to a customer standing in the bank and told the teller or cashier, right, that you should hand over the money to me. That cashier was petrified, was turned into inaction and silence. He would not move. Please remember, every paisa in the bank is insured. Even if he had paid, it would have been covered by insurance. There was no loss for the bank. But he was unmoved and nothing could he do. Then this robber, he lost his cool, patient, and shot the customer and left. The customer's family sued the bank for damages. The argument was this: look, the money was secured, insured, you should have paid, then it could have been recovered, but you did not. That's why my family member lost his life, the breadwinner, so you should compensate. Then matter eventually reached Illinois Supreme Court. Then they've said no. Why? If such ransom, such threat, a crime pays, every time somebody goes into the bank, show the gun, hold someone for ransom, and then they get it done. They said crime should not pay. Now, we always feel, let heavens fall. That's our motto in Karnataka, the Kerala High Court. Let heavens fall. Justice must be done. Is it so? Not even heavens. We don't want even walls to fall. I'll tell you an example. Literally walls to fall. I'll tell you an example. A very celebrated English case. That's with regard to a person has a private ground and he has let it out for cricketing teams so that they could come pay some charges and play over there. And to cordon off the grounds, he has had a compound wall. One day, two teams were playing, and then one guy hit the ball, sort of a sixer. It happens very, very rarely, perhaps once in a blue moon. The ball sailed over the compound and hit the passerby on the road next to that grounds. And that man died. Then that man sued the ground owner, right? The ground owner. Then House of Matter reached House of Lords. House of Lords said, no, he's not liable to compensation because economic efficiency of loss comes into play there. Suppose by having a ground, by having a compound wall, you have taken all reasonable care possible. Not extraordinarily reasonable care, but reasonable care. And then if you have to say at any rate it should never sail over, then you should have as tall as sky perhaps the wall. It becomes prohibitively costly. Nobody would let out the grounds. And then these people will not have a chance of playing. And that's why the game gets affected. In the larger run, please remember economic analysis. That's what Richard Posner has said, the economic analysis of law. That also plays a very vital role. These are the factors judges always think when they decide, right? We always think ex post, they always think ex ante. This is one thing. Then the second one I'll tell you, that's called in psychology confirmation bias. You know what's meant by confirmation bias? See, it's quite a common saying, first impression is the best impression. Our client comes to us and he tells us or narrates his version, and we fall in love with that case. So we own it up and it becomes second nature to us because we live with that one. We draft that one, we file it, we plead it, and we do everything. So we always feel our client is right. It's good to some extent, but it has its limitations, right? And on the other side, the other advocate, whom the respondent or the defendant briefs, will have the same thing. So we always believe our client is right. Why this judge with all his intelligence and all these things can't realize such a simple thing? Please remember, we tend to read between the lines, but judges are to read. They're bound to read only the lines. So this confirmation bias is also another factor that we need to take care of. And the third important one for young lawyers, I would like to say, I always say this one, the curse of knowledge. You know what's meant by curse of knowledge? I'll tell you, there's a good book on that aspect, one chapter, that is Steven Pinker's the best writing for 21st century, Steven Pinker. In that one, he tells an example of how you have to inform an uninformed reader, including a judge, your problem to be conveyed. In that sense, he says, suppose a friend of yours comes after a long while to your town and he wants to come to your house. He doesn't know where your house is located. Then he calls you. You tell him, come to so-and-so street, take third left, and then 2 corners later, take right, this, that. There is a big pole, there is a poster, next to that is my house. So he tries, he attempts, he fails. And let me assume that he is a civil servant or is a senior lawyer, whatever. Then you get frustrated because 3 times, 4 times you guided him, but he could not locate your house, which is so obvious for you, right? Then you feel, oh dear, he's such an intelligent man. I thought he couldn't even locate a small house, which is quite obvious. That's why the saying is there, what is obvious is apt to be missed, right? But remember, since you know it, you always feel everybody knows it. That's why when you start arguing before a judge, your knowledge you impute to the judge also. Please remember, judge doesn't know anything, but he can't read every file. So facts wise, his knowledge is zero. But because you have internalized the facts, and this curse of knowledge says, as you know, everybody else must be knowing. That's why always imagine as to the facts, the judge is ignorant. So don't ever think that a judge is dull or uninformed just because he can't catch up, because he doesn't have your exposure, because you have had it for a long time. Then, how do the judges think when they decide? This is another thing. We all expect in a classical way that a judge is an umpire, inert gas which doesn't react with anything, is like inscrutable sphinx sitting quietly, and then party A argues, party B argues, then he weighs them when it comes to civil, preponderance of probabilities, when it comes to civil, criminal, beyond reasonable doubt, and then decides. This is the classical way of thinking, right? And there are other moral schools of adjudication, then theological or religious schools of adjudication. All these things are there, but classical or former school of adjudication is one thing where judge has never been attributed motives. We always feel he's been absolutely value neutral. Then American jurists have started another school of thinking that's called American School of Realism. This is based on your upbringing, based on your social, political, economic background as a judge, and various other cumulative factors. You have a particular way of looking at the things. If you read Stephen Covey's book, 7 Habits of Highly Effective People, there he shows you at page, say, 24, one picture is there. He tells you, before looking at that page, look at page 40 and then look at it. Those who look at page 40 and then look at 24, they will say, that is the photo of a young, beautiful woman. Then he tells another group, controlled group, look at page, instead of 40, 60. Then look at page 24. Those who look at first 60 and come back to 24, the same picture, they say it's an ugly old woman. See, this is the power of perspective. Same picture with your exposure. When I was practicing in Tirupati, we used to have a joke, anecdotal, maybe somewhat true as well. We used to have a wonderful judge as a magistrate. And when it comes to the criminal cases, most of the times he was liberal and he was acquitting. And husband acquitted, father-in-law acquitted, brother-in-law acquitted, but mother-in-law was convicted. The reason is, they say, it's anecdotal, I said, with great apologies, that his daughter suffered in the hands of mother-in-law. That's why that American jurist and American Supreme Court judge, he says that the times that affect the rest of the people will not pass by the judges untouched, right? They do, Benjamin Cardozo, right? They do affect them also. When I was practicing in Hyderabad, there was a political battle between two parties. One particular party leader was arrested. And whenever there was a bail application for his release, that day morning, the most popular newspapers, at least supposedly against that particular party, will literally run written arguments in those newspapers why he should not be given a bail. And the other newspapers, they will run counter articles, news items saying why he should be given a bail. I'll tell my own experience in Kerala. I have come out to Kerala. Then most of the times I faced one problem, translation. Because all of the judges except the Chief Justice and me, they were Malayalam knowing judges then, now too. And they faced no problem. As far as I am concerned, I faced a problem. And I told all the judges, advocates in the open court, please bear with me. For 6 months, I will learn Malayalam. Difficult language, a tall claim. I've never learned. There's a different story. I know only one word, Vellam. Right. Then I said, I will learn in 6 months. Please bear with me. Then translation not needed. One advocate, I don't remember, he stood up and said, my lords, kindly don't learn our language. I was taken aback. I asked why. He said, if you learn our language, you will read our newspapers, you will watch our TV, and you will get prejudiced. How true? Maybe, I don't know, right? So, this is how the perspective matters. Judges are not neutral, judges are not inert. But please remember, they have no axe to grind. Their only endeavor is that they should render justice, they should decide correctly, and nobody should suffer on their count because of their limitation in understanding things. This is only the concern. That's why I said, if you assist the judge in arriving at the right conclusion, you are his favorite. This is how the judges do behave. Then, patience. Mr. Hariraj has said, right? Patience is a virtue. I agree. Absolutely. I'm just telling the perspective of a judge. You see, cricket, because I come from Hyderabad, usually I do give examples of cricket, but you give examples of Kerala Blasters football, right? Well, in that sense, a batsman effortlessly scores 99 runs. Then he struggles to score the next one run to complete his 100. We always feel, how come this man has scored 99, he can't score the next one run? Please remember, 99 plus 1, it's not 1. It's again 99. It's as difficult as is scoring the remaining 99 runs. In the same way, what happens? At best, we have 4 cases, 5 cases, 10 cases a day. So your patience is measured by the number of cases you have. Whereas a judge will have 70, 80 cases, right? And when I was in Kerala, my bench partner, I will not name, always tongue in cheek, lot of fun, you would say, brother, he would lean into me, brother, have you read this file? I say, yes, sir. Yes, brother, I have read it. He says, what do you say? I say, yes, he deserves notice and stay. We should give. But allow him to argue. He will force us not to give. Right, in the tongue in cheek. But the fact remains, you know, you study law, you study facts, kindly study the judge as well. You will have some notions. They may be cultural, they may be academic, right? All these things. For example, I was told, subject to correction, if you are in Europe, if you are traveling to India, you are traveling to, say, Gulf and other places, those tour operators will give you a orientation class with regard to the cultural aspects. Some cultural aspects which are normal for them, they offend our notions and vice versa. For example, in South India, sitting cross-legged before elders, especially women, it's not appreciated, right? And in Islamic culture, sitting cross-legged, showing the what you call the sole of the foot, is almost offensive, right? And please remember, when somebody comes to our house, we offer tea, and the guest is always somewhat diffident and very, very diplomatic. He doesn't want to embarrass the host. He will say, no, madam, I don't want anything. Then the host insists, no, no, please have something. Anything will do, madam, coffee or tea. Why we say? We feel if I say coffee, if it's not there, the host feels embarrassed. If I say tea, the same thing may happen. Okay, I say no. If they give whatever they give, it doesn't matter because we are very nice people. Whereas in European culture, in American culture, if you say that, they feel offended. You have to specify. Does it have any logic? No, it's a matter of culture. Right. So that way, kindly study the judge as well. And there's a one good book by Brian A. Garner and Antonin Scalia on that one, Making Your Case. There he says the first thing is study your judge. Get the whole dossier on him, his conduct, his preferences, his philosophy, his policy. Because we just look through the color glasses for the good, perhaps. Right? So this is another problem, another one. Now, let me take off another example. How to get success in this profession? Right? Have you heard about the saying, burn the boats or burn the bridges? In phrase and fable, it's been attributed to Philip of Macedonia, the father of Alexander. He started invading the whole of Europe. By the time he came out to River Thames, Then beyond Thames were not England per se, but a few principalities like what you call Saxon, Germanic, and other tribes were there. So they crossed the river. He must have started off at Macedonia with a big army. By the time they came down over there, he was left with about 10,000 soldiers. They crossed the river Thames and they could see the army of the native army there, about a lakh, outnumbered by 1 is to 10. No, he told his soldiers, burn all the boats. Burn all the boats. So it's king's command after all. They burned the boats. When they burned the boats, then he told them, look, we have been outnumbered. But the fact is, either you fight until death, or fight and run back, get drowned. Whichever is the honorable option, you go for that one. So, of course, instead of having an inglorious drowning, they thought of a glorious victory. That's why this legal profession is one thing where you should never have an alternative. You should fight as if your life depended on it. During COVID, I was asked by a Goan Lions Club that, sir, we all have felt very depressed. So we need some pep talk. Why don't you online have a talk on that topic? All right, I too didn't have any much work there, so especially during COVID. So I said that one. Then I told one incident. That is, one day I was going to the gym across the road in Goa, my official bungalow. I saw a very hungry, emaciated dog, and it spotted a cat, and it thought it had its food for the day. It was hungry, obviously, so it chased. I became curious. I was looking at it whether it could catch hold of. Then it ran, then twists and turns, the cat tried to escape. All these things was being watched, and eventually the cat escaped. Then I asked the dog. Then they realized it was a story. Then I asked the dog, how come? You're stronger, you're bigger, you're hungrier too, but you could not catch hold of it. Then the dog replied to me, please remember one thing. I ran for my food, it ran for its life. In our profession, you want success, don't run for your food, run for your life. This is another vital aspect that may have to. And another aspect, the one thing I love about Kerala advocates is, I was startled when I came over there. A young lawyer would get up, he will tell his facts, and he will say, case law, this. And the other advocate would stand, my lords, that case was overruled by Supreme Court last week. Again, he will stand up and say, no, millets, yesterday it was referred to larger bench, that larger bench has given this one. I was amazed at their alertness and their ability to produce case law. Then, one day, a learned senior advocate argued before me about a service jurisprudence matter. A principal was removed from service without due process of law. Then he said that one, I appreciated. He cited one judgment, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. He had a few more because the briefing counsel is handing them over. Then I told him, case law is like underlining a point. The more you underline, the very point will disappear. So, my young friends, always think in original thinking, believe in original thinking. And case law is only a prop when you're unable to stand. Once you can stand on your own strength of reasoning, logic, legal analysis, nothing beats it. So, the bar and bench are not two things. I always say I am like a mermaid. That means half man, half fish. I am half judge, I am half advocate. Any judge, for that matter, who has retired and resumed his practice, he can never shed the memories of being a judge. So we'll have a bit of perspective on that one. And that is that the judges have no axe to grind. They always look forward to doing something really remarkable so that they go down in the history as the best judges. They would be remembered. Who else can help them to do that one except us, the lawyers? That's all they look for. This is the perspective as how the judges think and what the advocates expect. And equally, they also expect from us that we'd better lead them to a safer landing of justice. Thank you very much. Please remember one caveat on my part. I need to catch a flight. I am right now in airport. I have come over here. I have taken a room nearby so that I could immediately catch my flight. There is a wedding tomorrow in my family, my nephew's wedding. That's why let me have up to 8. I can have my questioning. Then 9:15 is my flight. I have to start here and go there, check in. Please go ahead.
Thank you so much, sir. That was an enlightening and deeply insightful discussion, shedding light on the inner workings of the judiciary and the art of effective advocacy. Thank you, sir, for your wisdom and generosity. We will check the comment box and get back to you with the questions now, sir. And we also request our viewers to share your questions in the comment box. So one question that we've received is, to what extent does a judge's personal values or philosophy inevitably influence their application of precedent, and how does a conscientious judge mitigate this?
Yeah, wonderful question. It's a moral dilemma for every judge, to be or not to be. I believe 95% of the judges don't allow their personal preferences to color their judgments. 5% maybe. This is my experience. We are all human. 5 to 10%, yes, you give that benefit of doubt. The rest, no. Those who are devout may have held very secular views on points, and there are certain judges who believe that they should leave everything at the doorstep and resume everything once they get into the house. Until then, they are judges and judges alone.
Another question that we've received is, how critical is courtroom demeanor, courtesy, and ethical conduct to an advocate's reputation and effectiveness before the bench?
Another beautiful question. I'll tell you, when you argue, the judge takes from what you articulate only 25%. The remaining 75% he remembers only because of your body, the gesticulation. Your body speaks more than your mouth. So you can't stand like a fixed, a frozen statue and then deliver. It needs to be, please remember, an advocate is a performer, an actor. And as Judge Bernard has said, teaching is 1/4 learning and 3/4 theatrical. So should be the advocates.
Sir, another question for you is, a jurist with experience in Andhra, Telangana, Kerala, and Bombay, and now is a senior advocate of the Supreme Court, what will be your advice to the young members of Kerala Bar? What we lack and we need to strengthen?
Well, my advice, very simple. Nobody is special. Nobody is superior to you. Don't accept to be second best. You should be the best. Right? I don't ever accept anybody's greatness. If you want to, there's a wonderful book on that one, that is Bounce by Matthew Said. Please read that.
Thank you, sir. That concludes our question and answer session.
Thank you very much.
I invite Advocate Aruna to deliver the concluding address.
1 minute, Aruna, please. I think Senior Advocate Harija just some questions. I saw him raise his hand. No.
No, sir, I was only clarifying.
Hariraj must have said enough. Please go catch your flight. We meet quite often.
Okay, thank you, sir. Aruna, please.
Thank you, sir. Honorable judges, respected senior counsel, Dama, Seshadri, Naidu, sir, distinguished dignitaries and dear friends, I express my heartfelt thanks for the opportunity graciously given to me to conclude this session. It is always difficult to speak after such an eloquent speaker like Naidu, sir, and even more challenging to conclude a session handled so beautifully. But I'll try my best. As a young lawyer, finding my way through the profession, Sir has always been someone I deeply admire and look up to. During his time as a judge in High Court, I had the privilege of appearing before him on several occasions and witnessing his court in action. They helped me. They helped to shape my understanding of what it truly means to be a professional, not just in how one argues a case, but in how one should carry oneself as officer of the court. In his role as senior counsel, Naidu sir is continuing to inspire as a whole. And even when, sir, you were in feeling well, you still found time for us, and thank you so much for that. And to speak about the session. Like every lawyer secretly wishes that they could peek into the mind, inside the judge's mind during the argument to understand how the scales are tilting. But we can't do that. Each judge has his own or her own unique approach in dealing with the cases, but it is of utmost importance for an advocate to understand what is expected of us as a lawyer. And today we had the privilege of listening to someone who understands both worlds deeply and expressed it with such clarity. As Harraj sir said, our duty as lawyers is to argue, not to quarrel. Yet, how to argue effectively is something we often forget while on our legs in court. So my takeaway from this session are quite a lot, in fact. But to summarize what sir said, the dearest judge is the one who does not mislead. I think it truly captures the essence of our profession and what is expected of us as lawyers. And I think his advice to answer the judge's query first is a profound lesson in courtroom discipline and effectiveness in arguments. It is true that we lawyers always have confirmation bias, but that may help in preparing well in our cases, but that also is a lacuna we have in understanding the judge's reasoning. So I think if we shift our approach from formulating arguments to persuade the judge to genuine assistance, it will become a partnership in the delivery of justice. It is also equally important to understand the judge, remain patient, stay original, and preserve relationship without burning the bridges. Thank you so much for such a wonderful session. And before I conclude, I would like to extend my heartfelt thanks to Honorable Justice Jaishankar Nambiar sir, Executive Chairman of ILI Kerala State Unit, and to all the esteemed judges and dignitaries who joined us today. I would also like to thank members of Executive Council of the ILI Kerala State Unit. My sincere gratitude also goes to Harraj sir, also to Pavati ma'am and Unisa for their unwavering enthusiasm and dedicated efforts. I thank everyone who participated with keen interest and made this a truly memorable session. Thank you so much.
Thank you very much. Thank you, all of you, for the opportunity.
Thank you, sir, and have a wonderful evening.
Thank you. Thank you.
Good night, sir. Good night.
Good night.